Hello, and welcome to the Hildebrand Law Firm topic for today. I'm Attorney Matt Kaplan, and I am joined by one of my favorite coworkers, Attorney Derek Daron, one of the partners here at Hildebrand Law Firm. He handles a lot of probate and probate-type things, similar to Hank Hill, who handled a lot of propane and propane-like accessories. So Derek today wanted to talk about the very pertinent topic of heirship issues. So one thing that I've always wondered about heirship issues is when it comes to generating lift over the wings of the heirship, I don't understand how big ships like that end up getting in the air.
Yeah.
Please tell me about that.
So basically, there's a coefficient. It's called a drag coefficient. And if you couldn't tell, I'm completely making this up because, of course, I have no idea what kind of airship Matt is talking about right now.
Oh.
What I know more about is Heirship, H-E-I-R.
Oh, that type. Okay. That's the airship you were talking about.
Yes.
And we were talking about drag coefficient. You're talking about drag, like, that kind of drag?
Well,
okay.
Yeah,
perfect.
Yes.
Of course. A conversation Derek and I have often here at the firm. So, heirship with an H, which up until 5 minutes ago I didn't know existed. No, I knew that, of course. And so, Derek, I guess first let's start off with some definitions. Can you tell us what is an heir?
Sure. So an heir is going to be somebody who's recognized at law as essentially who's going to receive your stuff if you pass away without a will. In a probate case, we still notify all of the heirs, even if somebody has a will that leaves all of their assets to someone else or to a charity. Those heirs are usually, like I say, next of kin. In cases where someone doesn't have a spouse or children or surviving spouse or surviving children, those considerations can get a little bit crazy because we do have cases where brothers and sisters, for example, are the next closest heirs to an individual who's passed away. And so when you get to that level in the state of Wisconsin where you're talking about brothers and sisters, those brothers and sisters who have predeceased, their children actually get notice of our probate proceedings. And it's particularly relevant for people who die without a will because, to use a recent example of mine, I have a client who, of course, had a will back in 1975, which I think for me, I still think we're in the year 2000, so that doesn't sound quite so long ago. But that was 50 years ago. We still have it on the original typewriter parchment paper. So it is there, and it is a copy of that will. Obviously, in that case, we have the ability to administer that estate according to the will. But if we didn't have that will, and again, having that will be 50 years old is causing me a little bit of concern as well in terms of whether the court will even accept it. That individual passed away with, I believe, 8 brothers and sisters, only one of whom survived. Those 7 deceased brothers and sisters then also had a smattering of their own children. Some of them had no children, but some of them had 2 or 4. And then when you get to that line of succession in the state of Wisconsin, we actually then look to see if any of those kids passed away and did they leave kids behind as well. And so it's very easy, and I think it's been some time, but I think my sort of record for heirs is around 33, where someone passed away and they had $75,000 that had to go through probate. And so at the end, some of these great nieces and nephews are getting checks for $127.52 because they are only a 132nd share of the estate or whatever that fraction may be.
Sounds like a class action lawsuit.
Yes, truly. It truly is.
So one thing I've always wondered, Derek, is that when you're doing an heir search, you're trying to search for people's heirs, how deep do they go?
Right. So it really depends on who's surviving.
Okay.
As I say, in a case where you've got a spouse and a children that survive, that's usually the end of the analysis.
Okay.
In cases, and this is the other interesting thing about heirship, is in cases where you have split families, where you have second marriages, where you have kids prior to the marriage or not of the marriage, that's where you start getting into complications in terms of, well, if dad passes away, we still need to notify dad's 3 kids, even if dad had 3 kids with new mom. And so that's where we get into not only issues with notifying people, but then we get into issues where if dad didn't have a will, Wisconsin has a lot of things to say about that split split family arrangement in terms of the default rules about who should inherit. So it adds into a lot of the complication. It adds into, for example, a spouse who's very surprised to hear that the estate that they built with their spouse could potentially be going to those other children, and in some cases even their own children. So it does add a lot of complication to it.
Yeah, very much so. So, like, with regards to heirship and some issues, what are some of, I guess, the most common issues that you see in this probate world?
Yeah, I think the one I just mentioned with the second family is really the issue where you have someone who's elderly who's in a second marriage. It's very easy in a probate context where these aren't direct family members, right?
Mm-hmm.
The dad's new spouse is not necessarily a direct family member to dad's kids. Sometimes they do have a good relationship, sometimes they don't. And so you end up getting a little bit of just distrust in general, whether that's merited or not. And so, yeah, you see, unfortunately, because of that distrust, because of the fact that we're going through this formal probate process, you see things get a lot more complex than they need to be. And particularly, you see because of that mistrust, you see attorneys get involved a lot more, and you see attorneys on both sides, which obviously raises the bill for everyone. So, yeah, that's one of the reasons that I always say, if you have a trust, you can bypass everything we've talked about today. You don't have to worry about heirship because you don't have to notify any heirs in probate. You certainly don't have to make distributions to, the second cousin twice removed, who otherwise would be the natural heir of the estate. And so obviously that's where we certainly recommend that trust.
Now, are ex-spouses or ex-in-laws included in heirship?
No.
Okay.
So, yeah. So
Good.
if someone has had, and in fact, there's a special rule in Wisconsin that if someone has had a divorce, but they are still in their ex's will, as long as that divorce happened after the will was executed, their beneficial provisions are removed. So they not only don't have to be notified, but if they were named in the will, they would essentially be treated as predeceased.
Okay. This is super fascinating stuff. What's the deepest you've ever seen an heir be used?
Yeah, I am thinking of a couple cases where, the example I gave where we've got brothers and sisters, we've got a significantly elderly person, someone in their 90s and had a lot of siblings, a lot of whom did survive for a long time, but in a case where they're all passed away, you get into that, sort of classic Catholic family where they had 9 or 10 kids, and they all had 4 or 5 kids. I think I've seen, so not brothers and sisters, but then their kids and their kids and their kids. So I think 4 generations down where we had a minor child then who was set to inherit. And because we didn't have a trust, not only did we have to inevitably pay out to a minor, which I think if you've seen some of our other videos, you know what kind of an issue that is. But you also had to have a guardian ad litem appointed in some cases for those minors. I think I've seen as far down as 4th generation from somebody who passed away, and again, somebody who probably never met the decedent, and certainly, in some cases, a decedent who they haven't seen certainly in 10 or 15 years.
And then they just randomly get a check one day.
Correct. Yeah.
Oh, man. How do we get on that list?
I know.
Should they be related to someone rich who doesn't get their estate planning done? Gosh. Well, and then last question, kind of unrelated to this topic, but something I've always wondered. People, from my understanding, they tend to fight about things that maybe don't have a large monetary value, but maybe have a sentimental value. And whenever they fight about things in probate court, lawyers tend to charge by the hour. What is an item or a group of items that you've been asked to fight for on behalf of a client that was perhaps not worth monetarily what they paid you to fight for it?
Certainly, yes. So personal property is a big issue in a lot of probate cases where if you have a lot of close relatives who have a sentimental attachment to some of these personal property items, the stuff that's in your house, so to speak, so your couches, TVs, knickknacks, furniture, that sort of thing. There are, obviously things of great value in terms of personal property. Some people have art collections or have, china or things that are truly monetarily valuable. But in a lot of cases where you have, say, 4 kids and you don't really have a clear direction on what should be done with this stuff, One of the things that I've seen done, for example, is everyone takes a different color sticky note and puts it on different things. And so I have had in some cases litigation where, person A really wants, I'm trying to think of a recent example. There's a case where they were fighting over a laptop, not necessarily because of the value of the laptop, but because they thought there'd be stuff on it related to mom and mom's estate and everything else. It's quite a few years, but you see that stereotypical divorce court where they're fighting over the Beanie Babies, or
Sure.
they're separating Beanie Babies in the divorce court. The mattress, I've had people fight over the mattress too. I mean, it's only worth at best a couple $100, but somebody really wants it, and it's, by the time you have your attorney make that call and try to have that be split, yeah, unfortunately, you've paid the attorney more than the mattress is worth in the first place.
Yes.
And you'd be surprised in probate cases, especially because of some of that distrust that I mentioned earlier. People are really willing in some cases to fight over that stuff.
And I can imagine it's kind of easy because they're not the ones writing the check to the lawyers. It's all coming out of the big pot, right?
Yes, in most cases, yes.
So, yeah, well, really interesting, fascinating stuff. Thank you, Derek. This stuff about heirship has always been so interesting to me, especially with regards to, what happens when you don't get your planning taken care of. And people always talk to Derek and I saying, oh, we've got it taken care of. We have a will. We have this. We have that. As Derek has educated us, it just doesn't usually get it done. And you might run into some of these issues of deep, big families. You might run into something like that. So stuff is super interesting. Stay tuned for the next episode where we will actually be talking about heirships. Me going to the University of Dayton School of Law, I have an affinity towards air travel. Of course, Dayton being the home of the Wright brothers who invented flight. Who actually didn't. They stole it from some guy in France, but they perfected it, and that's what a true American does. And so join us for the next video. Just know that here at Hildebrand Law Firm, we're here to protect your today and your future. Thank you so much.
Thank you.